Welcome back to CBC News Network tonight. I'm Carole MacNeil. Great to have you with us. As we told you before the break, the Supreme Court of Canada says the federal government does not have a duty to consult First Nations before they draft legislation. So what does that mean for Indigenous rights in this country and for lawmaking in Canada? Joining me from Ajax, Ontario tonight via FaceTime is Pam Palmater. Pam's the practicing lawyer and chair of Indigenous Governance at Ryerson University. From Toronto, Tasha Kheiriddin, host of the Tasha Kheiriddin Show, and from Ottawa, Globe and Mail columnist John Ibbitson. All right, let me get, Pam, your sense of this. What are the implications of the Supreme Court ruling?
Well, there are huge implications. I mean, the Supreme Court is acting like Canada and the provinces aren't already engaged in pre-legislative consultations. I mean, the federal government right now has been involved in country-wide consultations with First Nations on their federal legislative framework to recognize First Nation rights, because as they told First Nations in all of those sessions, that the federal government has a legal duty to consult with First Nations before they pass legislation in regards to First Nation rights. That's their understanding. That's our understanding. That's what the jurisprudence has led us up to this point. So this case really knocks all of that off the rails.
It does, because it's the highest court in the land.
Yeah, and it's a real shock. I mean, they're literally overturning essentially 3 decades of jurisprudence that has built up, first of all, define the duty to consult, what the parameters are, how the government has to enact on it. I mean, we all now have duty to consult policies across the country, federal and provincial and First Nation ones. So this is really a step back.
Okay, Tasha, do you believe it's a step back?
I'm not sure if it's as much of a step back as Pam thinks it is, and I'll explain why. I think that, yes, there is a sense of a need to consult, if you will, with First Nations when there are a lot of laws that are drafted or policies that are changed. I think what the court was expounding on here was the clear distinction between bodies like, the National Energy Board, thank you, and Cabinet and others, which are executive bodies or regulatory bodies, versus legislative bodies, which when they draft a law, there are multiple groups whose rights are also recognized in the Charter. You can think of women, you can think of Quebec, for example, that could be affected by those laws, that if this were upheld by the Supreme Court could say, well, wait a minute, what about us? Should there be gender lens for budgeting, for example? I mean, the Trudeau government already does that, but would you want to have it enshrined in a judicial decision is the question. I think the government itself is in a position now, Trudeau has said this, he wants to redefine the relationship between First Nations and Ottawa, looking at Section 35. I think the judgment here sort of says, look, basically it leaves that open. If he wants to do that and put the country in a position where the legislative process can be stopped in its tracks by First Nations or any group in theory, then that's open to him to do. But I think the court is clearly saying, look, act with honor, yes, whatever that means, is a bit vague.
Yeah,
but
we'll talk about that in a second.
Yeah, the duty to consult is not one that can be acted on before a law is passed.
Okay, John, what do you think?
I don't think it's as grave as Pam says it is. Certainly what has happened is the rights of Indigenous Canadians to be part of the governing process have not been advanced. And that's really what was at stake here. Were we going to declare that First Nations must be consulted during the drafting and implementation of legislation, or does their existing right to challenge legislation after it's been passed in the courts as unconstitutional, as in violation of Section 35, does that remain the yardstick? And the court says that remains the yardstick. And I think, while I understand that it's certainly theoretically interesting that the executive on the one hand has a duty to consult, but the legislature on another does not, and I can see why you would furrow your brow. There was just, I suspect, the court recognizing the practical considerations.
Yeah.
Every piece of legislation has an effect on Indigenous Canadians one way or another. How would you draw up a budget? Budget provisions have to be kept secret, at least in theory, until the budget is delivered. But consultations leading up to the budget would in fact divulge the intent of the budget. And could you have injunctions between second and third readings if a particular Indigenous group decided that the consultation process had been violated in a parliamentary committee? it would have made Parliament essentially unworkable. And the court, I think, maybe did press itself into a bit of a pretzel in order to ensure that Parliament could continue to get the job done.
Okay, Pam, what about that idea that it would have made passing legislation in this country so onerous and slowed down the process so much as to make it unworkable?
It's so ridiculous. And here's why. Because federal and provincial governments have literally cried before the Supreme Court of Canada over and over and over again to say, we shouldn't have to consult on these things, it'll be too onerous. Or we shouldn't have to, change our legislation because it'll be too administratively difficult. And every single instance, the Supreme Court of Canada says you cannot use difficulty or extra burden as an excuse not to uphold a constitutional right. And what we're talking about here is Section 35, which is different than every other group in the country. The Supreme Court of Canada specifically said Aboriginal rights are specific and they can't be compared to any other minority group. And then you have the situation where this is already happening. Bill S3 was an act to amend the Indian Act, and the Senate completely rejected it under the Trudeau government because they asked one question: did you consult with First Nations first? No, we didn't. Well, there's a legal obligation to consult on this legislation before you do it, so we're sending it back to you. And they had to engage in a process of consultation. So it's not like this is some bizarre concept. It's something that should be because of the Constitution.
Can I just interject for a sec? Amending or changing the Indian Act, absolutely, there is no question that would affect First Nations directly. But you could say that, as John pointed out, there are so many laws where one could now say, waterways, for example, that was the case here. Budgeting could be another. Marijuana, there's a huge one, affects First Nations, affects all Canadians. But this is the problem, is that every bill that's passed, in theory, could have an implication, and that implication, however remote or close it would be an occasion to stop it in its tracks by the failure to consult. Now, the duty to consult is also not fully fleshed out. We saw this with Trans Mountain. The consultations were deemed insufficient. They happened, but they weren't sufficient. So I think the Supreme Court also took that into account, because the duty to consult also isn't, it's not set in stone by law. It's not the same in every single case. So it would really create a situation where you could have laws stopped because someone felt the duty wasn't sufficiently enacted, but we don't have clear guidelines. It would be unworkable in my view.
Pam, is there can I ask you, is there a consistent definition of consultation within the Indigenous community of what that really means?
Well, does it have to be consistent? I mean, even the Supreme Court of Canada said there's different types of consultation for different processes in different circumstances. Some First Nations have Treaty 8, which is very different than the pre-Confederation treaty. So of course, consultation is not going to be the same. You're talking about different fact circumstances, but the concept of the duty to consult, what's generally required, the fact that there's a spectrum, that's well known. And the Supreme Court of Canada has been saying over and over and over and over again, so many guidelines, that this is about negotiations, that this is about good faith, that the honor of the Crown is equally a constitutional principle, as is the constitutional principle around the parliamentary supremacy. And that's why Justice Abella said, this isn't about one or the other. You have to make these principles work together if you're serious about constitutional protection for Section 35.
But Justice Abella, just for the audience
reconciliation.
point of view, that Justice Abella was one of the dissenting opinions on this. Tasha, you were saying?
I think I'm going to say that, in fact, I think perhaps it is because, in part, the government has said they are going to be undertaking these discussions. They are undertaking these discussions with First Nations with regard to what Section 35 really means and giving it more teeth. Trudeau said this in February. He wants to do that. The court maybe does not want to usurp the power of the legislators to do that, because while I agree there are different types of consultation, that's part of the issue. The degree of consultation is different. Governments don't necessarily know what is required in each circumstance. I mean, we could see this, for example, with the inquiry into missing Indigenous women and girls, and the fact the previous government said no, we don't have to have an inquiry. This government says we do. How do you set those bars? I think they are waiting for the legislators to do that, which is what Trudeau has said he will do, which could open a whole other debate. And I think we have to have that debate about what the relationship is between First Nations and the federal government.
John, what do you think happens now?
Well, I think we wait till the next case. I mean, we're on a continuum here. Many Indigenous, especially many First Nations leaders, believe that the word consult means veto, that ultimately what the First Nations want is the right to object, to veto projects that materially affect them, especially on contested lands. Legislators, generally speaking, would like there to be no need to do anything at all. They would simply like to preserve the supremacy of Parliament. The Supreme Court has, as Pam points out, for decades been saying to both sides, you need to come together, you need to negotiate, and Parliament, you need to understand clearly that you have a duty to consult First Nations. It's there in the Constitution. But First Nations, we are not yet prepared to accept that you have a right to veto what happens at the federal level. The court does not want to make a final decision on that, I'm pretty sure, and it's going to continue to keep the waters as muddy as possible while trying to impress upon both sides that they need to find a political solution to this problem, not necessarily a judicial one.
The National Chief of the Assembly of First Nations says there are important lessons to be learned from the Supreme Court decision. And he says that while the ruling says there's no duty to consult Indigenous groups, the second part of it confirms that it's better if you do. Take a listen.
The message to me is to governments, sure, in the drafting of legislation, they don't have to consult First Nations people. But I think the rights lens, the Aboriginal rights lens, the treaty rights lens should be used in drafting those just to make sure there's no big, costly, timely, big fight in court when it comes to our rights and title. And so that's kind of the message to me now, that governments must work with us in a good collaborative way to get good laws and good legislation to uphold and maintain the honor of the Crown at all fronts. That's how I interpret it initially.
Okay, the honor of the Crown. Pam, explain to us, what is the honor of the Crown?
The honor of the Crown. Well, it's one of those things you can't take to the bank. It's one of those vague, wishy-washy ideas that, comes from this constitutional protection of Section 35, that the government is presumed to live up to its obligations, that it'll act in good faith with First Nations and impair their rights minimally. As we know from the hundreds of cases, that's not what happens. And every time a court allows the government to use its discretion about whether or not it's going to act honorably, it rarely ever does. And it's also very dependent on which political party is in, which kind of politics is in during the day, and constitutional rights shouldn't be that way. And I think Justice Abella, she was very specific about the fact that what this essentially does is guts this constitutional protection, because the duty to consult in every other case applied to the Crown as the Crown is the Crown. There was no differentiation between, well, which Crown are you talking about? We know as Indigenous peoples, Canada is the Crown, the provinces are the Crown. It doesn't matter whether it's the legislature or whether it's the executive. In fact, they're the same people. So you're really making distinctions that undermine the honor of the Crown.
They are not, but that is
very much undermine the honor of the Crown.
That is a problem. They are not the same people. This is the distinction. And I do agree. I think that there is a distinction to be made, because the legislative process is different from a decision from cabinet. It's like the United States. Executive orders are different from a decision from Congress. People elect their representatives to come together and make decisions. If that process can be stopped, as John pointed out, between second and third reading, can be just ground to a halt, we would have an obstruction of Parliament, because again, the duty to consult, government can say we consulted, First Nation could say you didn't consult enough, and then what happens? It goes to court before the law is actually passed. And this is the concept of judicial review. Judicial review is that you review the constitutionality of a law after it actually exists, not before. The government has a duty to charter-proof things. That is their obligation. If they can't do that, the law will be thrown out later. And that is, I think, the process the court wants to uphold, and that's why they made this decision.
You're shaking your head, Pam.
That's horribly unfair. You're asking the most impoverished people in this country, who don't even have running water, to come up with tens of millions of dollars to fight Canada on a case-by-case basis every time they shove legislation down our throats. And that is not reconciliation, and it's certainly not honorable.
All right, well, we have to leave it there for tonight. Pam Palmater, Tasha Kheiriddin, John Ibbitson, thank you for joining me tonight.
Thank you.
Thank you.
Thank you.